That's a really good point. Why don't we all start to move like forward, toward the front, like we walk, not be on to so much cozier.
I'm gonna listen.
Oh, it's this one here, yeah.
Oh, sorry about that.
I don't want to be
So did she just pass on?
I'm not staying for the afternoon though. I guess it doesn't matter. I know. Isn't that
Hi.
We see each other more now
I know.
than ever.
Then I know. I took 1 year and I mean I've been back in for a while. I don't know. It's just I know I see what it is and it's like I know.
exactly.
Hi.
Hey, how you doing today?
I'm here firsthand. We had
Mark.
Kate.
Yes. Yep.
I'm Holly. Come here.
Okay. Probably, yeah.
Good to see you guys.
excellent? How are you?
Actually,
Hi, how are you? Hey, how are you? Good. There's Lisa. Everybody's here. Yeah. I'm gonna like a little
All right.
Good, how are you?
I was gonna say it's volleyball.
Siesta Key both days. Women's open on.
All right, we should start in a second here. We still have a couple more judges that I know are trying to wrap up and get on their way. It's been one of those Fridays. We'll be joining us here in a minute. Are you really staying way back there?
Just walking.
All right. All right, well, yeah, I get that. All right. Feel free to move up when you're done chatting. All right, let's see. Judge Wilson and Judge Doherty coming this way as soon as they get settled. We'll get going. This presentation is being recorded as well as the one this afternoon. So if you don't have the ability to stay for the longer session this afternoon, you can find that on the link to the Ninth Circuit on my page if you want to take a look at it later. Very chivalrous. Very, very chivalrous. All right, so welcome everybody. Thank you for joining us today. I think it's going to be very educational and interesting. We have three of our family law judges with us today. Not everybody could make it schedule-wise, but we try to get a good balance. I think we've done that. I'm going to start out by asking each of the judges to introduce themselves, what division they're in, and maybe give you one or two things that they would like you to most know about their either policy, philosophies, peeves, whatever strikes them. And then I have collected over the last few weeks some topics from some of the family lawyers that I've been speaking with that I think are topics that everybody's probably going to be pretty interested in talking about. So we're going to do some of that, and then I'm going to open up the floor for questions or areas that you'd like to have conversation about. So I'm going to start to my left with Judge Blackwell. Oh yeah, you got to turn the mics on, by the way.
I think I turned it on. Yes, okay, yay. Hi, I'm Alice Blackwell. I sit in Division 46,
domestic division 46, which is the domestic violence division. And as you know, we pull in related DR cases once we enter final injunction. So I just would say that we are continually looking for ways to try to improve what we do and are open to suggestions and ideas. If there are things that we can do to better accommodate you and your clients, we would love to hear about it. We try out different things. Some of you have our little beepers, and we're trying beepers for uncons to give people a chance not to stand in the line, although it seems like everybody stands in the line anyway. But, you know, we're trying to make that more user-friendly for your clients, and are always interested in ways that we can improve or do something to make your lives better as you deal with the domestic violence divisions of the court.
Good afternoon. I'm Judge Alicia Lattimore. I'm also in the Domestic Violence Division, and I am in Division 44. So I work along with Judge Blackwell as well as Judge Wooten. And I would say that, just a reminder that you all are very important in the Domestic Violence Division when it comes to kind of communicating between the two parties who are not having contact with each other, being able to, particularly if there's another lawyer on the other side or U.S. counsel, being able to speak with the opposing party to try to get an idea as to whether or not there's some matters that can be, stipulated to or resolved. We have forms that you can fill out for stipulations. But you all have a chance to kind of communicate between the two parties a lot better than we're able to do at times because we have such several cases scheduled for those return hearings, and as you're waiting to be called in, that gives you an opportunity to maybe give and speak with them and resolve some of their issues, since they don't only come along with the matters as it relates to the injunction, but also those family matters with children, time sharing, etc. So that's my contribution to the introduction.
Good afternoon. I am Judge Tanya Wilson. I am in Division 31, so I am in the Domestic Relations Division. I think what I found is that the attorneys do a really good job of talking to one another, but when there are pro se litigants, I don't know if they feel intimidated about calling you. I certainly don't have a problem with pro se litigants talking to attorneys about the case to move the case along. Sometimes I found that the pro se litigants, they've never spoken to the attorney, and I'm like, you can talk to the attorney, that's okay. So I do that a lot, but I think you all have done a really good job to one another. The only other thing that a lot of you give me your case law, your memoranda before the hearing, which is extremely helpful. Just to make it a little easy, you don't even have to for me a site. Email that to Kim and just give me a site. Then that way you don't have to pay your printing costs or whatever you have to do. I don't know if you have to pay to download from Westlaw or not, or fast case, but just give me the site and that'll be fine. But I want to thank you very much for those of you who do it. Thank you very much for passing on your case law before we have the hearing.
Thank you, Tanya.
You're very welcome. How are you?
I'm wonderful.
I appreciate it.
My name is Mark Blechman. I think over the past 4 months, I've had at least 90% of you here in front of me. I appreciate the family law bar. I've been criminal for 35 years, so it's a nice change. I like it. As Wilson just said, the way you all get along with each other, it makes everything go smoother, both for the court system as well as for your clients. I appreciate that, and I see that happening. If I had one, I'm new to this, so everything is new. One suggestion is, I don't know if you know this, but when you file something with the clerk, we don't get it. So we don't know that something's been filed. So it would help me, and I actually have an order on the internet requiring you to send me notices and the motion that you have for any short matters here. And I need that because I don't want to look so stupid when you come before me that I don't know the subject and don't know what you're asking me to do. So I would appreciate if you would help me out by sending me email me the notice, email me the motion, so I can look at it. I look at everything the day before I go home. Next day, everything quickly, I can get you out quickly. So you all can do that for me. I think you all working together really helps the system, and I appreciate that.
Good afternoon, everybody. I'm Patricia Doherty, and I'm assigned to Division 38. And I do want to echo what the other judges have said and say it really is to serve in this division and to have the benefit are, and as far as how you do work together. I've been in the division, in the general domestic division, probably the longest of the people up here on the stage, so most of you have been in front of me. I guess what is a little surprising is that a lot of you don't know what my particular division of days or schedule is. And so we aren't all the same as far as when our trial days and when our hearing days are. So that's the first thing to recognize if you didn't know that. So in Division 38, for example, I hold hearings on Monday and Thursdays, and trial days are Tuesday, Wednesday, and Fridays. And that may help you a little bit when you get your notice of trial and pretrial, so then you know my trial days are Wednesday, Thursday, and Fridays. And again, there are some differences. Thank you. Yeah, then you that's right, thank you. So Wednesday and Friday, that may help you on thing. I just want to say that we all recognize that hearing time is gold, and it has, since I've been in division, I am constantly evaluating that and looking for ways to create more hearing time. I reorganized some things in my division. One thing we did along the way, you may not have realized it, is, for example, the unrepresented parties who file motions for extended temporary custody by extended family, they're now being processed through our family law intake center. Those on our uncon docket. We don't have to use regular. Open up from 8:30 to 9 if I don't have uncons. I just keep kind of tinkering just to try to find more ways to make a 24-hour day into a 34-hour day. But having said that, we are so happy to have Judge Myers and his division in our family law group now.
Good afternoon, I'm Don Myers, and I'm in the newest created division of the domestic division inside of our services here in Orange County. This is not my first time in domestic. I actually began domestic out in Osceola County as a brand new judge 7.5 years ago or so. I'm excited to be back. I love and consider it an honor to be able to speak into the lives of families that are in crisis, and I do recognize that's where a lot of your clients are. We start off by saying one thing that I'm particularly grateful for, and that is how respectful our domestic bar is interacting with pro se individuals. The challenges in the domestic division are the number of pro se parties, and it's a challenge. Manner of approaching, of dealing with, of not taking advantage of, not running roughshod over is incredibly respected, I know, by the entire bench, and so I thank you for that. Two things that are just maybe hot buttons for me. If I have a question to ask you, I really want you to answer the question. And I know you're laughing because maybe you've experienced that. If there's something working in my mind, right, wrong, or different, until I resolve that, it's really hard for me to move on with your argument or with the testimony. So do me the courtesy, respect us enough to respond to the questions that we ask directly. I know that there are hard questions, and we don't want to respond to them. That's intention. If how firmly, how strongly we believe that your argument wrong. Do I know law? And that's frequently the question. Because I haven't been a practitioner in this area, I am looking to you for guidance on that. And so sometimes your response back in the right direction, so thank you. Second thing is this, I have 4 children. I'm an adoptive father as well as having children born after to me. My kids are great kids, I love them, and I find it very difficult sometimes to sit in this division and watch families disintegrate. When you are cross-examining a parent, take it down a notch. When we walk out of that courtroom, these 2 folks have to figure out how to co-parent. And the damage that can be done in cross-examination, in my experience, can be incredibly difficult for some of these folks to make your point. I'm not suggesting you shouldn't, but do it in a respectful way. I get it, but I didn't get it. Ask me if I got it. I don't consider that to be disrespectful. Indeed, it's respectful to the folks that are there. We're going to have to try to work through this process together when we all walk away from our long time.
Okay. All right, so I have a very exciting introduction to make, but first I want to give credit where I believe credit is due. Judge Doherty has worked tirelessly as the admin judge of Family Division, advocate for you and your clients in ways that you may not fully appreciate. We had Judge Meyer come on board as another full additional family law division, and that we thought was just a godsend, but Judge Doherty was not done giving where we needed it. We have, and I'm delighted to introduce you to her in July, another new family law judge coming on board, Julie O'Kane. I don't know how many of you practice in front of Judge O'Kane. I know I tried one murder case 3 times in front of her because I just couldn't get enough to do this one again. It was just too much fun. Judge O'Kane is super right and super efficient and always extremely prepared. And I think you're going to just love having her in addition to other judges. You're welcome to join us up here, Judge O'Kane, if you'd like to. Get cozy with the groom. After you ask Judge Levin, he'll give you the nice chair because he's like that.
Hello, everyone. I apologize for being late.
Is there anything that you'd like them to know?
I think just a couple of things. And my expectations for you will be no different than my expectations for any lawyer who has it here before me when I'm in the criminal division or in the civil division. Is that I expect everyone to be professional. I expect everyone to be, hopefully you'll be able to answer my questions. I'm with Judge Myers on that one. And I expect you to do your jobs and act like lawyers. I never forget a lawyer who leads me into error. And I did not practice family law as a lawyer, and I have not served in the family division as a judge, and so this is going to be a new learning curve for me in terms of the substance. Obviously, handling non-jury trials, evidentiary issues, hand discovery issues, I've got that all down pat. It's just going to be learning the substantive law, which I feel I'll be able to do. But please don't leave me to error.
All right, and I'm Diana Tennis. The only thing that I would add, and I'm going to talk a little bit more deeply in the 3-hour session this afternoon about Division 30, it's been my impression that there are cases that are going to trial because nobody had the time to make them settle. And I'm up there kind of sometimes wondering, why on earth are we here? And how am I going to make mush? And somebody's going to be really unhappy with their lawyer when I get this final judgment. I just implore you to have earlier, more honest conversations with your clients about what it costs to get through a trial where you've got to actually present every bit of ridiculous dissipation argument they want to make. I don't feel that they are learning the cost of this soon enough and may well be shocked. I also would encourage you, make these people pay you. Make them pay you. And get money to go to trial. You're not doing anybody any favor in trial 40 grand in debt to these folks, and you're not gonna get paid, we've had a trial we shouldn't have had. So anyway, that's my plea. So a couple of things have been, asked of me, a couple of these really resonated with me, as would be fabulous to know. One question I got was, do all the judges have the same pretrial order? Well, the essence of all of our orders is fairly consistent, and I know that we send those around and we work on those, but I'm fairly confident that we all have probably minor differentiations. I don't know if this is consistent across the board, but I require everybody prior to trial to exchange the actual exhibits that they're going to use. Whether or not they've been requested or in discovered or whatever else, you gotta exchange the actual exhibits. I don't want anybody using anything in the middle of the trial. And the caveat to that is, when you get to that point in the trial, and done it, it's probably they didn't follow your pretrial order or your trial order, because the case law says there's got to be some sort of cost to you, or what would you have done differently, or I would have done this differently, or I would have looked at it, or I could have challenged it, or whatever. So I add that, but I try to be pretty consistently firm on that rule. The other rule that I have that I'm not sure if anybody else does is, once you've gotten that exhibit list, I require the lawyers to file something that says, these are the ones that I have objections to. So that we don't have this argument in the middle of trial as to do the bank records get in or the bank records don't get in. If you're going to require a business certification, you absolutely have a right to do that, but I want everybody to know it ahead of time. And that way, everybody can play fair. Your bank records get in, mine get in, or I'm going to object to yours, so you're going to object to mine, and we can all not have lengthy conversations during the trial about exhibits. So I'm going to open this to the floor. Nuances to your might be different than the norm. I'd certainly like to learn about some of your tricks myself.
My pretrial order requires you to mark before you come into that courtroom.
They all require you to, you just aren't.
There's just no way that we all require the same thing, and you all know that, because it doesn't happen. At least half of you are probably unhappy with a decision any one of us makes when you leave that courtroom, maybe more than half of you. In which case, a record might help you in appealing our decision, so another court can look over what we did. It can't do that if you don't have items marked when you're showing a witness an item and you're not describing what that item is to the record. So I encourage you to, follow all of our order and have items marked before you come in that courtroom, before you show it to a witness. That's not just for trials, it's for hearings too. And let's say 80% of the attorneys that appear in front of me don't have anything marked for any hearings. We have an abundance of those yellow tags in our courtroom. I'm sure we all have them available. Pick them up whenever you're around and use those and mark them.
They come with an instruction sheet. They're simple instructions. Follow the instructions. I just finished a day-and-a-half long trial, and the trial was an extra hour and a half because of the process of dealing with exhibits that weren't marked or properly marked along the way. There's limited time, and we want to get to the heart of the issues in your case. Help us to do that by being prepared with something that's really pretty straightforward.
Anybody else have any tidbits you want to?
I've seen Judge Blackman's order that says pretrial suggestion. That's your problem.
I did forget one other thing that is like a huge pet peeve of mine, and that is dividing up these folks' stuff. So my pretrial order basically says I'm going to burn stuff. No, it doesn't say that. What it says is that there has to be one list, one single list, not her list that says the brown couch in the foyer and his list that says the yellow love seat in the front room. I'm not going to do it. There has to be one list, and it should have what their valuation are, as ridiculous as they be, and then a spot for me to put in the, you know, the just over gross sale value next to it. It has to be one that's, it's just crazy making. Yeah, go, please.
So following up on the equitable distribution sheets, I mean, that is a recurring theme in courtrooms where people come to trial and they know there's assets, either there's no equitable distribution list for the judge, and we're counting spoons and forks and, you know, tables or chairs, and then you miss all of the elements. An equitable distribution sheet ahead of time that's agreed upon is also a good checklist for you. Not only reminding you of the items, but what you need to address. You know, that fair market value, data valuation, all of that, and that's a good little check for you because it is for people to miss an item of proof, and we can't address the item again. The other thing is it's fair market value, and time again, your clients are getting up there and testifying as to replacement cost, how much either or what they paid for it, or what it costs to get a new one, and that's the only evidence given to us. So that so by doing the equitable distribution sheet, one, it's a good checklist for yourself, but two, write fair market value on it to remind yourself.
All right, so let's talk about something that is an ongoing issue, I know from our perspective because of how we have to deal with that, and that is emergency motions. So I'd like us all to kind of give you our philosophy on that. I will tell you that in 3 and going on 1/2 years, I want to say maybe signed 2 ex parte emergency motions. I think I regretted 1/2 of those. So I say that's not too bad. I have a very instinctual, come from a criminal defense background, aversion to ex parte, lack of due process stuff. I am very unlikely to sign an emergency motion that has not been provided to the other side, absent very, very remarkable situation. Emergency motions that do include notice to the other side, minorly better, except that we're supposed to be dealing with those in 24 hours, and so what's the chances that other lawyer is really going to have an opportunity in 24 hours to cobble together a response? I don't sign those very often either. I do fairly regularly take a look at it. If this seems like a thing that I really need to get my arms around pronto, I will set a hearing within a couple of days. That's my most typical reaction to those things. I will say just in the few that I've signed, I've gotten burned a couple times by lawyers who put something in writing only later to have it turn out, no, not so much. And in the one situation where I thought it was particularly egregious, I awarded fees. I'm not going to play that. So that's kind of my philosophies around emergency motions. Why don't we go down the line, because this is a really important topic, and I think everybody needs to hear.
I would agree with everything that you said, Judge Tennis. It's over time, as you see emergency motions and grant them, and then have the hearing afterwards and find out that, yes, there was another story, you learn to look at them very, very, very carefully. And the other part to me that's so significant is courts are inherently forensic. We tend to operate after something happens and not so much in advance of things happening. And so, particularly when you're alleging future harm, it's very difficult for us to find that to be an emergency unless it's of a physical nature. If there's going to be physical harm or removal of the child from the jurisdiction of the court, and there's real proof that that's about to happen, it's going to be difficult for us to respond quickly. And so I would just tell you that you need to be really careful not to be known as the lawyer whose clients ask all the time for emergency relief, because the other piece that you don't see that we see is that we don't just get like one emergency motion a week. We get multiple emergency motions a day. And a lot of that is because pro se parties put emergency on everything, just about because they learn that if they do, we'll look at it right away, as opposed to looking at it 48 or, 72 hours later. And so there's a constant flow of emergency motions that comes in, and it does tend to see something really extraordinary to deal with that. That being said, like Judge Tennis, I set aside emergency hearing time every week. For me, every 3 weeks, I set aside emergency hearing time so I can get them in if I really think parties need to be seen right away.
Let me touch on something that Judge Blackwell said, 'cause this is really, really important. For those of us who do a lot of scouring the file stuff, like I get ready for every hearing, I scour the file, I get ready for the pretrial, I scour the file, I get ready to start the final judgment, I scour the file. I'm really pretty intimately involved in your files. When I have lawyers involved that have a 2-3 year litigation and there's 5 or 6 emergency motions over time, most of which I would not have seen because it came before me. My spidey senses are, these people are a problem. It doesn't inure well to what it is we bring in the background as far as our feeling about the tenor of the litigation. It doesn't help much. So they try to talk them out of this when you can, because it just doesn't make them look good. All right, sorry. I'm gonna try to touch my website.
So, yes, I agree with everything that's said, and typically the way that I approach emergency motions is that, not in all cases, but again, if parties are attempting to remove the children from the jurisdiction of the court, that surely is an issue that's gonna get my attention, but also I'm pretty much looking for those real emergencies, something that really is going to be something where I need to take immediate action, but I actually had a motion recently in regards that was titled emergency in order to save the cats. And so I thought that probably would rise to the level of me issuing an emergency order. Although I do like cats, and I really, but I love dogs more. Implicit bias may come out.
Are you saying you did not sign that order? Oh, I'm so signing that order.
But I did suggest if you want to set it for a hearing, contact Judge Diane.
Yeah.
I've told people before, that cat better show up.
Yeah.
You better be finding that.
My thing is that, and particularly where you all can be helpful is that you're speaking to your client and being honest about what is an emergency. Just being honest, this judge is not going to consider this as an emergency, as well as I often, when I read motions, start asking questions. The first questions that start popping up in my head, and oftentimes that is, well, did they contact the other opposing party to see if somehow this can be resolved short of them filing a motion, particularly an emergency motion? And so that's, my judicial assistant thinks I'm crazy because I'm often in my chambers just yelling out questions, just reading the motion, like, did they do this? Did they do that? What about this? So I just think that it would be helpful as attorneys, as counsel, before you file that motion, to make some attempt to reach out to the opposing party or counsel and, see if it's something that one can be handled short of a motion, not just emergency situations, but any motion that you file, but particularly emergency situations, so that that for us, because as we have indicated so far, there's a very slim chance we're going to sign an emergency motion unless it's something that really needs our immediate attention.
There's one. Yeah, red is good. I know, it's great.
For me, I do echo their sentiments, especially when Judge Lattimore said, I'm looking for blood, guts, death, gonna be dead. I'm looking for heavy stuff. Please, I'm down on my knees. Don't send me an emergency motion because he didn't pay child support. Or the alimony is $7 7 months late, that's a whole different motion. That's not an emergency motion. I don't find financial issues to be an emergency. So if you could just remember from me, blood, death, gut, something on a horror show, that's what I'm looking for, or a kidney thing. That's kind of, I think that's it.
I think I've only had one attorney emergency motion, so I don't see an abuse by you all. But somebody in the clerk's office is saying, write the word emergency on every single pro se motion. Because I'm getting 4 and 5 a day, and they're not emergencies. But that's not your fault, because I think I've only got one from an attorney, and I didn't, I was punished for that later on. But it was well written. I don't remember what I had, but I don't see any abuse by the attorneys using that, so I have no negative comments or suggestions for you.
I don't really have anything to add, but it is always interesting to me, in attorney cases, when I'm mailed the emergency. Just make that observation.
Obviously, I don't know what family emergencies already had. I haven't experienced them.
Love's got some kids.
Except my own family emergencies. Just so you all know, I am married and I have children, so I've got at least some perspective on some of the issues. But what I would say is that, when you make a filing with the clerk's office, when you file something, it is being filed when you file it. But that does not mean that it automatically appears in the Odyssey system, which is what we have access to. And so if you have any emergency motions that you want me to address, you need to contact my office and deliver it, either hand deliver it to me or send it to us via email, because otherwise I don't know that your emergency motion has been filed. And then the only other thing I'll say is I'll share what Judge Dick Conrad said many years ago when I came on board as a new judge, and he said, lawyers' failure to prepare does not create an emergency for the judge.
Can I just say something before I forget? I'm old, so I forget things. When I mentioned earlier about emailing me the notice of hearing and motion or short matter, I don't need a cover letter. Don't spend any extra energy on that. Just send me what you're sending the clerk, so I have it. And I don't want to create more work for you all.
So I'm gonna let Judge Doherty and Judge Blackwell, if you could lead the conversation on this one. And this is something that I'm a little befuddled about myself. So I'll tell you what I think the system is, and then I'll tell you what I feel like the experience might be for some. When there's uncon with lawyers involved, an uncontested divorce, my understanding is that if there is something kinky about it, they want to waive or have a different child support amount or do a child support deviation, they don't want to file financial affidavits, they don't, their time sharing schedule, they don't want to do the holidays, there's something unusual about it. I think I thought what was going to happen is that it would get bounced back to the trials division. We would deal with whatever the weirdness was and then enter their final judgment that same day, or however it is that we decided to kind of deal with that. I think what's happening with them is that they're under the impression that they have to come to the trial division, get us to sign off on the deviation or not sign off on it or whatever, and then go back to the DV uncon, through the DV uncon process. And I don't think that's what we intended them to have to do, but I think that's what we are doing.
Well, yeah,
We've actually talked about
we've been talking about
Yes.
this because we recognize it's a problem. Understand that to help get the lawyer uncons done on a timely basis, we've done a couple of different things. One is to have the DD judges do it because there's a certain amount of time in the mornings that it takes to process the DD cases, and we can just use that time productively doing your uncons. The second thing that we've tried to do is we've opened up another day. We were doing 3 days a week, now doing 4 days a week, and I think we've really caught up time-wise. And you can get your clients in a lot faster now than you used to, because we were sort of running behind. So we agreed to add an extra day, so we're doing Tuesday through Fridays now, uncons, and it feels to me like you can get in a lot faster than you used to be able to do it. Here's the problem. It's not our case. It's not our case. And so when our JAs are reviewing it for completeness, if there's a problem, if you want something waived or you want to do something out of the ordinary, because the case doesn't belong to my division, I have to refer you back to the other division. And then I don't care where you do your uncon, I'm available to do it, but if the other division, in hearing the issue, wants to do the uncon at that time, that's fine with us. We're not married to doing the uncons. But our JAs are trained to tell you, I need this document, or I need this waiver, or I need this, and then if you want to come back, call us. So I think, Patty, as I understand it, we're not telling people you have to come back to us, but we're available.
I think that may be the impression they're getting.
Yeah.
But I also think it's a division by division situation. Because I can say what happens frequently in my division is, first of all, the most is a child support deviation. That's probably one of the most common. So the case is referred back to the division judge. Frequently, if I know the motion for deviation of child support is filed, we will tell the attorneys we can also this is for your final hearing at the same time. And I've done many of those. But we have to know about it, for one thing. Because what's happening is people come to short matters in ex parte and deviation and element of the statute as far as the court has to make a finding. One lawyer pops into short matter, agree to this deviation when you sign off,